Assalamualaikum law fellows, what's going on? If you are new on my YouTube channel, please subscribe it and do share with your law friends. Today we will discuss about the conciliation, which is the most important topic of the alternative dispute resolution. Now we will move towards, first of all, we will define what is conciliation. Basically, conciliation is a process in which a conciliator resolves the dispute between two or third parties. Now we will move towards the silent features of the conciliation. Conciliation is a voluntary and highly confidential process where a neutral third party, known as a conciliator, steps into the assist disputing parties. The primary goal is to help them arrive at a mutually agreeable settlement, fostering cooperation rather than confrontation. It is distinct from the traditional mediation. Conciliators are empowered to propose non-binding settlement terms. This active guidance helps steer the parties towards a resolution, providing concrete suggestions that can bridge gaps and overcome impasses. The process rigorously focuses on clarifying complex issues, enabling parties to assess the strengths and weaknesses of their representative positions. It encourages a realistic evaluation of their case and the through exploration of various settlement options. Now we will move on the next slides. The role of the conciliator. The conciliator acts as the impartial expert, skillfully facilitating communication between parties and actively working to reduce tensions. Their expertise ensures a balanced discussion and a productive environment for negotiation. It identify the issues and provide guidance. A key responsibility is to identify and clarify the core issues at stake. Conciliators help parties understand the legal and practical implications of their dispute, offering insights that might not be apparent to those directly involved. The conciliator purposes the solutions. Unlike a judge or arbitrator, the conciliator purposes possible solutions without imposing decisions. This ensures that the ultimate agreement remains in the hands of the disputing parties, fostering a sense of ownership. The conciliator keeps the matter confidential and cooperate with the parties. They uphold strict confidentiality, protecting sensitive information throughout the process. The conciliator actively encourages cooperative negotiation, guiding parties towards a collaborative resolution. Now we will discuss step by step how conciliation works. At first, agreement to conciliate. Parties voluntarily agree to engage in conciliation, often seeking this route either before or shortly after a dispute officially arises. This initial agreement sets the stage for a collaborative approach to resolution. At the second, conciliator selection. Through mutual consent, the disputing parties select a conciliator, and this selection is crucial, typically based on the conciliator's demonstrated expertise, experience, and an unwavering commitment to the impartiality. At the third, session structure and conduct. The chosen conciliator takes charge of structuring and conducting all sessions. They may option for separate private meetings with each party or joint sessions, adapting the format to best suit the evolving dynamic of the dispute. At fourth settlement proposal offered during the process, the conciliator may strategically offer non-binding settlement proposals. These suggestions serve as invaluable tools to help parties bridge difference and ultimately reach a mutually acceptable agreement. At last, post conciliation assistance. Should a full settlement not be reached, the conciliator does not simply withdraw. They provide essential assistance in preparing the case for the potential trial or guiding parties toward further alternative dispute resolution action. Now we will discuss the key benefits of conciliation. It is time and cost effective. Conciliation offers a significantly faster and less expensive alternative to traditional litigation or even arbitration. By avoiding lengthy court procedures, parties save valuable time and considerable legal expenses. It is a flexible and trialed process. The conciliation process is remarkably flexible, allowing it to be customized to the specific needs of the parties. This includes adapting the timing, language, and overall structure to be best facilitate resolution. It maintains confidentiality. A crucial advantage is the strict confidentiality maintained throughout the process. This safeguards sensitive information and protects business secrets from public disclosure, a concern often present in courtroom settings. It encourages win-win outcomes. Conciliation is designed to foster mutually beneficial resolution. This approach helps in preserving ongoing relationships, reducing hos- uh, it reduces hostility and building sustainable agreement that work for everyone involved. Now we will move on next slide. Legal context and application. Conciliation is not just a theoretical concept but a widely applied practice embedded within various legal frameworks, demonstrating its practical utility across diverse disputes. Widespread use across sectors and institutional banking and framework. At first, primarily utilized in civil disputes covering a broad range of disagreements, highly effective in family law matters and common in employment disputes, and increasingly adopt in commercial conflicts to maintain the business relationship and avoid lengthy litigation. In institutional banking and framework, court connected conciliation programs are common. The process is often governed by the established rule such as the Uniform Rule of Dispute Resolution, Supreme Judicial Courts, and others. While conciliation agreements are not binding, they frequently pave the way for formal legally enforceable settlements. Now we will conclude. Now we will Now we will differentiate with the other methods of the ADR. Conciliation versus mediation. While both involves a neutral third party, a mediator primarily facilitates dialogues and helps parties explore solutions on their own. A conciliator, however, actively process specific settlement terms, guiding the parties more directly towards an agreement. Conciliation is often a more directive process. Conciliation versus arbitration. Arbitration results in a binding decision handed down by the arbitrator, which is legally enforceable. In contrast, conciliation is not binding and entirely consensual. Parties are not obligated to accept the conciliator proposals, maintaining full court over the outcomes. Conciliation versus litigation. Litigation is a formal, often costly, and adversarial court process where a judge or jury make the final decision. But the conciliation is conversely informal, cost effective, and highly collaborative, focusing on finding common grounds rather than assigning blame or fault. Now we will discuss on why conciliation is chosen. Conciliation empowers parties to retain full control over the outcomes of their disputes while benefiting from the expert, impartial guidance from a conciliator. This balance ensures fair and mutually acceptable resolution. By opting for conciliation, parties can relax substantial savings in time, money, and emotional stress. The method actively contribute to build trust and preserving ongoing relationships, which is especially crucial in family, employment, or commercial contexts where future interactions are inventable. It is flexible and proven path. Conciliation stands as a proven, flexible, and effective path to achieving amicable dispute resolution. It offers a structured yet adaptable alternative to the courtrooms. It was small effort to convey my thoughts about the conciliation. If you find any errors in that, you can openly criticize on that presentation or that topic that I present. Thank you for watching. Allah Hafiz.